this international webinar on intellectual property and environmental law. At the outset, everyone knows that what is this intellectual property? Intellectual property refers to any intellectual creation of mind. And you might have read even in jurisprudence the kinds of properties like the tangible properties and intangible properties. Keeping in mind that the basic knowledge and when you proceed to this intellectual property, this law gives a right to own and profit their artistic, scientific, technological creations for a designated period of time. Inventors are granted to a variety of intangible assets such as ideas, business methods, inventions, musical piece, literary work, artistic works, discoveries, words, phrases, symbols, and designs. The primary objective of these intellectual property rights is to encourage inventions and promoting their protection and utilization so as to contribute to the development of industries, which in turn contributes to the promotion of technological innovations and to the transfer and dissemination of technology. In the light of this, if you look into the connection between this IPR and the environmental law also, look, we have this the different kinds of IPRs like geographical indications that which relates to this the link between IPR and the environmental law. We have other types of the IPR like patents, trademarks, copyrights, industrial designs, semiconductor integrated circuits layout design, trade secrets. Now, if you look into all these, particularly these types of rights are available to the owners. And in the light of this, the link between IPR and the environmental law, we have to look into the present day climatic the changes, the climatic changes in the globe, and thereupon we have to look into why this type of change is occurring in the globe. And if any person innovated new ideas in the sense of protecting the environment or even the climatic changes, we have to be looked into the innovations. Is it possible to protect his innovation or not? In that dimension, we have to deliberate over this. The patents, they are protecting the innovations and technological improvements that are new, non-obvious and useful. They grant inventors the exclusive right to make, use and sell their innovations for a limited period. Typically, it is for 20 years. And the research and development in the fields like medicine, engineering, software, and many others, including the environment, is also possible. The copyrights, they protect the original literary, artistic, musical, and other creative works like books, songs, computer programs, patentings, and films. Copyright owners have exclusive rights over the reproduction, public performances, recording, broadcasting, and more. This encourages creators to keep producing new works and enrich the society. The another the type of the IPR is trademarks, protects the words, names, symbols, sounds, or colors, and distinguish goods and services in the marketplace. Companies invest heavily in branding, so trademark protection is a crucial business to prevent consumer confusion and distinguish their products. Trade secrets, they're also another type of IPR, covers confidential business information that provides a company and competitive edge, like the formula for Coca-Cola or Google search algorithms. As long as reasonable efforts are made to maintain secrecy, trade secrets can potentially then last indefinitely. With this few introductory remarks, protecting the individual and intellectual property through patents, copyrights, trademarks, and trade secrets is a vital, fostering innovation, creativity, branding, and economic growth. Strong IPR laws benefit society by providing incentives the development of their inventions, books, music, forms, and brands that enrich our lives, including this environmental protection. With these remarks, I inaugurated this international webinar very happily, and I wish good deliberations and discussions will take place in this webinar. I wish all the participants and organizers and I congratulate the organizers for conducting this international webinar. I also congratulate and thank Professor Maruti, Dean, for providing this opportunity. All the best wishes for this webinar. Thank you.
Thank you, sir. Thank you so much. On this occasion, I would like to call to the president of the program, Professor Dr. T.R. Maruti. Sir, kindly share your perspectives on the intersection between intellectual property and international environmental law. Over to you, sir.
Am I audible?
Yes, please.
Yeah. Thank you very much. Good afternoon to each one of you, esteemed professor of law, and my guru, mentor, philosopher, above all, a very good human being who has in fact consented to share his views on intellectual property rights in this discourse. In fact, when I requested him to share his views in this occasion, he could give positive reply without any hesitation. And he's a well-known professor of law, cutting across India. And he has been actually teaching law in a pioneer university, Alliance University, School of Law, Bangalore. With these few aspects, I take this opportunity on behalf of Department of Studies in Law and School of Law, extend heartfelt gratitude to him for accepting our invitation. Thank you very much, sir.
Thank you.
For joining with us. Syed Kudrat, esteemed participants, paper presenters, above, ladies and gentlemen, it gives me great pleasure and honor to be a part of this webinar, which is being held on time. In fact, when I requested Syed Kudrat to have this kind of program at the international level, he could come out with a very good proposal on this issue of synergy between intellectual property rights and the protection of a human environment. So that's it. On the basis of these factors, and it was actually designed on the basis of Article 7 of our TRIPS agreement, trade-related intellectual property rights. You know very well. Yeah, I think I don't require to explore the intellectual property rights in otherwise manner. Everybody knows intellectual property rights are nothing but patents, copyrights, integrated circuits you have, then geographical indications you have. No matter, however you may have gone through, of course, there are as many as challenging issues in connection to the subject matter of the intellectual property rights and the protection of a human environment as such. As I believe, when you are dealing with property, series of theories are actually well noticed. If we just look into the jurisprudence, you'll be known many theories who have outspoken on the basis of the right to property, vis-a-vis obligations among the people or the states as well. So these are the things. As you already been known that where there is a right, there is a duty. Where there is a duty, there is a liability. This is our juror relations. One shall not be forgotten on the jurisprudence in the traditions as well. And you know that fact that in earlier days, whatever you had property, that property had to be called as a stolen property. Because there was no the concept of state. King was supreme. Whatever he wanted to say was the law of the land. And you know the fact that Raja Pratyaksha Devata, that was actually overruled when Magna Carta was introduced in 1215 in UK. Now, king is restricted. This is what even Hugo Grotius, father of international law, and Karl von Savigny in Germany, they say that the property which has been owned by individuals, in earlier days, that property had to be called as if a stolen property as such. So it is because of fundamental rights and freedoms in which you have overestimated on the basis of the century of experiences. Now you are claiming to have a property. So what is all about property? How exactly property should be looked into? What are its perceptions and ideologies? If you just look into TRIPS agreement, trade-related intellectual property rights, you will be known how exactly the rights have been actually overemphasized at the international level as such. As I said, it could be patent, copyright, trademark, integrated circuits, geographical indications. All in all, we have. Our concern is to have a look on a synergy between environment. As you have already been known, science means humanity. Similarly, technology. They should go hand in hand. Whenever you want to go for inventing something, that should be useful to the larger interest of the society. Public interest should also be actually called for and looked into. So without understanding the synergy between these two, whatever you are going to say in this webinar would be incomplete. Therefore, I'm just requesting all the participants to have a look on certain critical thoughts on the subject matter as well. This is one thing I would like to share before you. Looking into the various perspectives and ideologies among the nations, the problems between haves and have-nots are remained even today. Clashes between developed and developing are also remained. And you know the fact that these rights were actually overemphasized on the basis of economic imperialism. Economic imperialism is one of the major bases with a view to understand the intellectual property rights. How exactly intellectual property rights ought to be protected and where exactly they have come from. That's very important. You have to understand. This is one thing. On the other hand, if you just look into the very perspective of Article 7 of TRIPS agreement, wherein it has outspoken on the basis of a social, economic, and cultural welfare measures. So this is very clear. So why a TRIPS agreement came out with new approaches to understand the concept of environment. This is very important. What is environment? Everybody knows. There are series of principles are actually well noticed. You have polluter pays principle, sustainable development, precautionary principle you have, common but differentiated responsibility you have, common heritage of mankind you have. Rest of them, like public trust doctrine, all these principles, doctrines, and concepts are actually well noticed. Everybody knows. This is not exaggeration to state. In fact, the Supreme Court of India has been actually understanding the crux of the human environment as such. So protection and preservation of human environment is a matter of acceptability and the survival of our social system as such. Your economic conditions and the social conditions are always actually based on the well-being. That's one of the major aspects which shall also been actually called for. This is one thing. On the other hand, as you've already been known, in 1972, Stockholm Conference came out with new approaches to understand environment. This is one thing on the basis of the sustainable development. Later on in 1992, in Rio de Janeiro, two conventions concluded among the nations. That the UN Convention on Protection of Biological Diversity, 1992, then UNFCCC, United Nations Framework on Climate Change, 1992. Since then, it is one of the debatable issues among the nations. So it was because of these reasons you could establish as many as specialized agencies of United Nations. Why United Nations organization has been called for to understand humanity and the protection and preservation of human environment. We need them. That's one of the major aspects should also be actually addressed in this webinar as well. Of course, no matter when you are dealing with intellectual property rights, it is a different. Of course, intellectual property rights have been actually defined as ideas, inventions, and creative expressions based on which there is a public willingness to bestow the status of property. This is one thing I would like to share before. IPR provide certain exclusive rights to the inventors or creators of that property in order to enable them to reap commercial benefits from their creative efforts or reputation. That reputation, creative efforts should be protected. IPR means I protect your right. You should know. Who has to protect? The state has to protect. This is one of the responsibilities on the part of a state to protect your right in the sense that in which you have meant for that. You have created that. It depends on, efficacy of a human being based on the, creative mind. You have to protect the intellectual property rights as well. So there are several types of intellectual property protection, like patent, copyright, trademark, etc. Patent, as you have already been known, is a recognition for an invention which satisfies the criteria for global novelty, non-obviousness, and industrial application. That's very important. On the other hand, IPR is prerequisite for better identification, planning, commercialization, rendering, and thereby protection of invention or creativity. This is one thing. On the other hand, each industry should evolve its own intellectual rights, policies, management style, strategies, and so on, depending on its area of specialty. Looking into the perspective of pharmaceutical industry, currently has an evolving IP strategy and approaching in coming area. So if you just look into the various challenging issues, the problems, you'll be known. There are major problems we have, especially in intellectual property rights. Take for example, registry issues, backlogs, and delays. These are the major challenging issues we have. On the other hand, we have, lack of experts in patent claims drafting for eligible works. This is one of the serious issues we have. Looking into the perspective of the cost of production, to register a trademark, we can expect to pay between $225 and $325 per class code, which does not include in a such or the attorney fees as well. So this is actually somewhat typical to understand the procedural issues as well. On the other hand, we have lack of awareness among these countries about the intellectual property rights. If you just look into India's perspectives, we talk many things on intellectual property rights. Theoretically, practically, it's very difficult to be feasible. And I'm just requesting all the participants to throw light on some critical thoughts on the subject as well. This is one thing. Looking into the perspective of developing countries, especially in African countries, have its worse situations. The information shows that in Africa, over half of the small and medium-sized enterprises have never heard about the intellectual property rights. This is very serious issue, especially in developing or least developed countries as well. See, why intellectual property rights are well noticed in developed countries. This synergy has to be looked into. Without understanding these crises among the nations, whatever you are going to say would be incomplete. This is one thing. Of course, no matter at the international level, we have series of international conventions which are actually dealing with the protection of intellectual property rights as well. Take for an example, you have a Budapest Treaty on international recognition of deposits of microorganisms for patent procedure. You have Paris Convention for protection of industrial property. You have a convention establishing the World Intellectual Property Organization. You have Berne Convention for the protection of literary and artistic works. You have Patent Cooperation Treaty. You have a protocol relating to Madrid Agreement concerning intellectual property rights, registration of the marks, and what we call it as a Madrid Protocol. You have that. Apart from these, you have a Nairobi Treaty on the protection of Olympic symbol. You have Convention for the protection of producers of phonograms against unauthorized duplication of their phonograms. So, apart from these, you have Marrakesh Treaty as well. So these are the conventions who have outspoken for the protection of intellectual property rights at the higher level as such. These are the things that shall also be actually looked into. I'm just requesting all the participants to address these issues in a better way, so that we can come out with new approaches to understand the synergy between intellectual property rights and the protection and preservation of our human environment assets. So protection and preservation of human environment, as I said, is a matter of acceptability and the survival of our social system. And better than me, that India is actually known for international relations. That's one of the major aspects shall also be actually looked into. You just go through Article 253 of the Constitution of India, wherein it has outspoken on the constitutional validity of public international law. So you have to understand on the basis of the balancing interest between municipal law and the international law while you're addressing the issues and challenges as well. Okay, so in this way, requesting once again all of you to take part in this deliberation in a better way, so that we can come out with some new resolutions which should be helpful to understand the synergy between human environment and the intellectual property rights as well. With these few aspects, I take this opportunity to thank each one of you for giving me an opportunity to share a few words about this international webinar. Thank you very much. Over to you.
Thank you, sir. As the coordinator of the international webinar on fragmentation, synergy, coherence of intellectual property and international environmental law, it is my pleasure to welcome you all participants, attendants to these intellectual property stimulating events. We have a diverse and comprehensive lineup of speakers who will delve into various facets of intellectual property and international environmental law. Each speaker has been allocated for the specific time slots to present their research and insights. Without further ado, let's commence with our first speakers. I call upon Ms. Asmatu Nisaji will kickstart our webinar with her presentation titled "An Acceleration of Green Innovation is a Policy to Environmental Sustainability," focusing on critical perspective from her position as Assistant Professor of Law in GSS Law College and Research Scholar in Karnataka State Law University, Hubli. And please join me in giving her a warm welcome. And following her presentation, we will proceed with the rest of our esteemed speakers according to the schedule. Remember, each speaker has 10-minute time slots, so let's ensure we stick to the allocated time to make the most of this webinar. Thank you. Let's continue with our exploration and fascinating intersection between intellectual property and environmental law. Asmatun Nisamam, the floor is yours.
A very good afternoon to one and all present here. Am I audible?
Yes. Yeah, you are audible. Please go ahead.
At the outset, I would like to congratulate University of Mysore for hosting international webinar on fragmentation, synergy, coherence of intellectual property and international environment law. which is jointly hosted by Department of Law and Institute of Legal and Policy Research. So the time allotted for me is 10 minutes from now. The topic which I have chosen for today's presentation is an acceleration of green innovation is a fallacy to environmental sustainability. I would like to start my presentation with an American entrepreneur and philanthropist quote, which is said by Bill Gates. I quote, "Never before in the history has innovation offered promise of so much to so much in such a short time. This year, World Intellectual Property Organization is celebrating the 20th World Intellectual Property Day with the theme Innovation of Green Future. This year's theme will look forward for economic value of environmentally sound solution and an importance of respect and patents in designing the new creation technologies for more sustainable future for all of us." Of course, intellectual property and green innovation has to go hand in hand. And this paper outlines innovation for green futures, which offers a chance to honor those working to protect our planet through sustainable solution. As people like Uzbek's Minister of Innovation Development, he and his team in the Center of Genomics and Bioinformatics developed a technology for growing drought-resistant cotton that has been patented in 5 countries and with the World Intellectual Property Organization, shortly called as WIPO as well. This technological advances will help sustainable cotton in phase to climate change and decreasing water resources, which is vital for Uzbekistan's economy. So entrepreneurs and innovators in medical field also depend on intellectual property rights. Drugs and pharmaceutical companies spend more than $100 million every year to develop a new vaccine and medications on to the protection of global population and improve health and welfare of the people. Many of these companies have also been developed new technologies to fight during COVID-19 pandemics as well. Launching of a new brand of product requires investment, research, and testing. Based on this, a hypothesis has been drawn, that is, whether green innovation is a fallacy to environmental sustainability because we are accelerating towards it, we are speeding towards it. And based on this particular hypothesis, which has been framed within a short period of time, the US Embassy seeks an opportunity to share American industry and ingenuity through mutual benefit partnership with entrepreneurs, businesses, and research institutes. And intellectual property rights directly or indirectly supports hundreds of millions of jobs around the world. University College of London, in its study 2016, found that green industries in United States provide nearly 9.5 million jobs. This study also showcased that US green economy generates $1.3 trillion in revenue per year, which is 7% of our domestic product in a solid intellectual property framework. So having said that, what is green innovation? It means green and innovation. It is a crafting and applying fresh, eco-friendly technologies, methods, or products. This concept covers various practices, including designs of energy savings technologies, renewable energy, sustainable materials, eco-conscious businesses, strategies, etc. So roughly India's more than half of the population is engaged in agriculture and food sector. This is how we use green technology. Great potential growth is being given to the government for an ambitious goal, that is doubling farmers' income and establishing 10,000 farmers producers organization by 2024. We have a very short period of time through green innovation to achieve this. Green Innovation Center in India is been there, which has been aimed to increase yield and income in a small holding farmers as well as a turnover to rural enterprises. So being a part of BMZ's special initiatives called One World, No Hunger, the Green Innovation Centers are global programs and were established with a network of 14 countries in Africa, including India and Vietnam. So what are some of the green innovation practices which is shaping India in future, and what are the drawbacks in it? The first and foremost thing, green innovation, most of the green innovations are patented. For example, solar paint, which converts building into energy sources. This is a groundbreaking innovations And this is transforming building into renewable energy powerhouses. Unlike traditional solar panels, solar paints is a liquid solution which is applied to the surfaces to absorb it and to convert it into electricity. This is a very important aspect which is a groundbreaking in the field of intellectual property as well. Its benefits are versatility, aesthetic appeal, cost effective, and accessibility. But it is having its own fallacy. Solar paint technology, which is also called as which is also called as photovoltaic paint. It reduces the use of fossil fires, no doubt in it, but it is suffering because of high incidence of pollution. Energy harvesting, which emerges and which converts the renewable energy for the advancement of thermal energy, is being widely used here, which creates light pollution, a sort of pollution which is now very emerging. And this developing captures energy from the sun, which is mechanical in nature. And researchers have also been continuously proved that the stability, the weather resistance, the scalability, etc., has been adversely affected because of this particular aspect, and it is having limited efficiency. 3 to 11% of efficiency of hover is being used for harnessing. So this is one of the fallacy in this. The next is edible packaging, which reduces plastic waste. This is also an incredible innovation which has reduced which has reduced the plastic waste and offering an innovative approach through sustainability. Green packing solution is being designed to consume along with the product. They are protected or they can be decomposed quickly if discarded. This initiative sufficiently cuts down the plastic weight, contributing to the environmental preservation. It is biodegradable material, that is its plus point. It reduces plastic waste. It also comes in food safety, innovations, and food industry. But what is a fallacy? Though this is a very extraordinary aspect of greenovation, despite the benefits of edible food packing, there are some still drawbacks, and they are edible packing is water soluble in nature. That means it breaks down in water and have a shorter shelf life than other packing materials. It directly or indirectly responsible for various environmental issues, including greenhouse emission gas, litter pollution, and overcrowd landfillings. So this is one of the most important fallacy which has been there in this, apart from the other important things which can be sidelined. Consumable packing is also a good response. Now, third important aspect is AI optimizes renewable energy efficiency. Artificial intelligence, what we call it as AI, plays a big part in improving the efficiency of renewable energy system. By analyzing a vast amount of data, AI can predict energy consumption patterns and optimizes the operation of renewable sources like solar and wind power, etc. This leads to more efficient use of resources. It reduces waste and increases sustainability, which is the need of an hour. And it is also very important for ensuring longevity and performances. The major important advances are it predictive analysis, it maintenance optimization, it stores the energy, and smart management system is there. The fallacy behind this is no doubt data management and security is a need of an hour, but it is in the energy sector, it relies heavily on the vast amount of data for training and decision making. So energy system generates an enormous amount of data from sensors, smart meters, and other sources. Critical ethical challenges are there. AI bias and fairness is also a greatest challenge which has to be ensured in the days to come. The scarcity of skilled talent both in AI and energy domain also poses a very important lucrative challenge. This shortage hampers the industry ability to full leverage. Now, the next important thing is green hydrogen powers, which is of zero emission, which is having versatility, and which is sustainable industrial fuel. And the fallacy behind it, it is a greater challenge for the supply chain. The vertical farms optimize urban space use, and aerophonic system, which is a very important growing system in this particular field of intellectual property rights, which is of space efficiency, which reduces transportation, which controls the environment, and above all, which have water conservation. The disadvantages is very meaningful in aerophonic system, that is water pollution is being caused. So vertical framing is there, which is of high cost. This is one of the disadvantage. Operational consideration is there. Plant vitality is being taken into considerations. So all these things are no doubt the intellectual property right challenges are there. Intellectual property right patenting system is there. But on the other hand, we can see the fallacies as well. Initiatives to protect green intellectual properties is also been there. That is the International Patent Classification System Green Inventories 2010 has been introduced by World Intellectual Property Organization for ecological sound technologies. Green's Energy Research Centers has been established in 2009 due to US and China considerations. Joint Clean Energy Research and Development Centers, that is called as JCERDC, has been established in again 2009. Green technology pilot programs have been established by US Patent and Trademark Office. Eco Patent Commons has been established in the year 2009 by World Business Council for Sustainable Development. Yet, the future of green innovation and intellectual property rights is again a challenging task because it is having a road cross effectivity, it is having a canons in it, and it is having an incubation inventions, which is again a time-bound engine of investment, innovation, environmental friendly technologies, which has always been in question. Thank you so much for giving me this opportunity to present my paper. I think I have done it within time without squatting over the other person's time. Thank you so much. Thank you, sir. Hello? Hello? Am I audible? Am I audible?
Yes, you are audible.
Yeah, you are audible.
Yes, sir. Yes, sir. Sir, I have done with the presentation, sir. Thank you so much, sir.
Okay. 1 minute.
Yes, sir.
Okay. Can you just talk to Kudrat?
Yes, sir. Yes, sir.
Yeah.
Syed Kudrat? Syed Kudrat is not here, I think. He is not responding. Syed Kudrat?
1 minute.
No, sir, he has sent me a message. Ma'am, I left. Please proceed.
Can you proceed your questions?
Yes, sir. Yes, sir.
Yeah, you can proceed one by one.
Yes, sir. The next presentation is Mr. Rehan Khan, and he will present a paper titled Human Rights Implications of the Intersection Between Intellectual Property, Environmental Protection, and Access to Resources. And sir is from Aligarh Muslim University, and sir has been given 10 minutes of time to present the paper. Over to you, Mr. Rehan Khan. Mr. Rehan Khan, are you here? Mr. Rehan Khan?
Just go to the next one.
Okay. So the next paper presentation is done by Mrs. Rebecca Sarah George, and ma'am will be presenting a paper titled Promotion of Climate Action and Activism Against Climate Change, Analysis on Legal Effectiveness of International Agreements. Ma'am is from Bar Council of Kerala. Ma'am, time is being allotted for 10 minutes. Ma'am, are you here to present?
Yes, ma'am. I'm here.
1 minute, ma'am. Before you present, let me tell Mrs. Srimati, yes, is the up next presenter. Mrs. Srimati X, please get ready. Thank you, ma'am. Over to you.
Thank you, ma'am. I'm here. So today I'll be dealing with the topic, the promotion of climatic action and activism against climatic change, analysis on legal effectiveness of international agreements. So if we look in the present topic, so what does this climate action mean? Like India, like other countries, has been experiencing drastic climatic change for many years as a result of this global warming, industrialization, deforestation, and urbanization. So the situation had worsened and created a lot of environmental calamities. So currently we are suffering from the climatic change. So it has a vast impact on the agriculture, animals, and other natural habitat, and even it led to the death of the humans. So climate action refers to the efforts which is taken to combat this climatic change and its impact. So these efforts include reducing greenhouse gas emission and taking action to prepare and adjust to both the current effects of climatic change and the predicted impacts in the future. So if we look at the Sustainable Development Goal 13, it advocates for the immediate action to fight against this climatic change and its consequence. So it is intrinsically related to the other 16 goals of the 2013 Agenda for Sustainable Development. So if we look at the Paris Agreement, it also restricts the global temperature rise to far below 2 degrees. So if you look at the international framework related to the climatic change, the main thing is the United Nations Framework Convention on the Climatic Change. So this has borrowed a very important line from the very multilateral environmental treaties, that is in the Montreal Protocol, that bound member states have to act in the interest of the human society, human safety, even in the face of the scientific uncertainty. So this is also known as Rio Convention, and there is a two open for signature, that is Rio Earth Summit in 1992 and Rio Conventions like UN Convention on Biological Diversity and Convention to Combat Desertification. So next, if we look at the United Nations Framework Convention on Climatic Change, so main thing is to stabilize the concentration of the greenhouse gases in the atmosphere and prevent any dangerous interface with the climate system. So this has been established in May 1992. And it was effective from March 1994. So there are a lot of annex which says about how much reduction targets should be developed by all the developed countries and the developing countries. And next, if we look at the another thing is about the Kyoto Protocol. So that was the framework under 2020. So there's a emission reduction obligation, that is obligation invokes in the annexure, as we have said. So there is a how much they have to reduce. Then there is a Paris Agreement. So it is in the Conference of Parties 21, which held in December 2015. So this was adopted as a framework that is applicable to all parties for the first time in history, that there is an agreement that have entered on November 4, 2016. Then we have Copenhagen Accord in 2009. So that is about the emission of the reduction targets and actions up to 2020 of the developed countries and developing countries. Then we have Cancun agreements in 2010. Then we have Durban Platform 2011. We have Doha Climatic Gateway 2012 and 2013 Warsaw Decision. Then we have Lima Call for the Climatic Action 2014. And we have a Paris Agreement adopted in 2015. Next, if we look at Indian way of Indians India framework of the related to the climatic change. So we have various environmental laws, like we have the Main Act, Environment Protection Act. Then we have Air Prevention and Control of Pollution Act, Water Prevention and Control of Pollution Act. So certain environment laws. Even we have a policy also. So so on 13 June 2008, a National Action Plan on Climatic Change was released. So main strategy of 8 submissions, that is to help adapt and magnify ecological sustainability. So we have National Solar Mission, National Mission for Enhanced Energy Efficiency, National Mission on Sustainable Habitat, National Water Mission, and National Mission for Sustaining Himalayan Ecosystem, the National Mission for Green India, and National Mission on Sustainable Agriculture. So on 3rd August, the Union Cabinet under the chairmanship of Prime Minister passed nationally determined contribution for consideration on the United Nations Framework on Convention on Climatic Change. So in order that India should reach the goal of zero emissions by 2070. So this was a transformation of Panchamath, that is 5 nectar elements. So India's action plan against climatic change was announced at the conference of COP26 in Glasgow, that is in UK. Then if we look at certain lacunas which we find in this analysis of the international environment law, we know there is a problem of the efficiency as well as the administrative power. So there is issues regarding that. Next, if we look at the Energy Conservation Amendment Bill of Indian Act 2020, the Ministry of Power has appointed Nodal Ministry and Bureau of Energy Efficiency as an implementing agency. So if we look, there is a question that is arising whether this Ministry of Power will be the right body to regulate the scheme. So as per the business allocation rule, it says that the Ministry of the Environment, the Forest, we look at that looks into the climatic change and the environmental norms. So in countries like USA and UK, the Environment Ministry will implement the schemes as proposed by the bill. But there is no clarity as who will regulate this carbon credit certificate as mentioned in the Act. And the interchangeability of certificates is not clearly defined in the same activity as may be applied to energy savings, renewable energy, and carbon credits. So if we look at the India have installed only 6.7 gigawatt of solar rooftop panels, which is less compared to the target of 14 GW in 2022. So this is another problem we find in the then the NWM does not address the issue of equity as a demand of the water among the affluent people is more, which has reduced the per capita availability of water for the lower section. So they faces major crises like the shortage of manpower, financial constraints, technical issues. There's a lack of coordination among the research and ministry. And then in the case of the NMSKCC, this involved the states yet to set up nodal agency, climatic network, capacity building initiative, and data. A secure payment mechanism remain absent for such institution, which holds energy efficiency projects. So they also suffer from the poor knowledge exchange between the energy suppliers and the consumer sectors. So we see new schemes like Amrit Hriday, Smart City Mission, National Urban Livelihood Mission, and Swachh Bharat. It focuses on the areas of the National Mission for the Sustainable Habitat, but they have drawn more attention from the NMSH. So the energy efficiency and sustainable habitat are yet to be incorporated in the urban planning process. So these are the major gaps which we find in the National Mission for the Sustainable Agriculture, which include less focus on the marginal farmers for the climatic change resilience and less attention to the adaptation scenarios. So it depends on this integration with the national programs on the agricultural development and food security. So that's it, my topics.
Thank you, ma'am. So you were having 2 more minutes. Anyways, thank you for such a good presentation on human rights implications, how intersecting between intellectual property and what is the recent developments which has been caused. Thank you for your excellent presentation. Now I call upon Mrs. Rebecca Sarah George for her topic entitled Promotion
Actually,
of...
my name is Rebecca Sarah George.
Okay, now I call upon Ms. Srimati S. upon the title topic Sustainable Development through Patenting Seeds. From Chennai, Dr. Ambedkar College of Law, Pudukkapam. Thank you, ma'am. Over to you now.
Thank you so much for the introduction, ma'am. Respected judges, greetings to everyone present here, and I hope that my audio is clear enough.
Yes, ma'am. You are clear, ma'am. You can proceed.
Thank you so much, ma'am. So myself, Srimati, a student of Chennai Dr. Ambedkar Government Law College, Pudukkapam, and I am here to present the paper titled Sustainable Development Through Patenting Seeds in this international webinar on synergy, fragmentation, coherence of intellectual property, and international environmental law. So to begin with this presentation, I would like to define the intellectual property rights. As we all know, these are legal rights which were given to the inventors and creators to protect their invention for a certain period of time. However, the exercise of such private rights over the living organisms has always been a subject matter of controversy and a matter of conflict. Even this complete ideology has gaining its different aspects and different perspective poles of the globe. We observe that some activists from the global south are completely distrustful towards the IPR regime and the exercise of IPR rights over the over the agricultural products and the product of land such as seeds. Whereas the international global institutions such as World Trade Organization strongly emphasize and strongly encourage the fact of IPR exercise over plant producers, and it also encourages the plant breeders to create new plant varieties. So it is obviously very conflict in nature. And today's my presentation completely relies on 3 dimensions. The first dimension being the important objections of seed patenting around the globe. And secondly, the need of seed patenting. And thirdly, how such seed patenting will be related to the sustainable development. So before that, I would like to clearly enunciate the fact how the seed is very much related to the sustainable development, because we have various goals of the GP related to the seeds, such as zero hunger, sustainable cities and communities, responsible consumption, production, and global action. And that India being a developing seed industry, it is almost the 8th largest seed industry all over the globe, with turnover of about 920 million per year, per annum. So this establishes how the seed is very much interlinked to the sustainable development. And we also know the definition of the sustainable development is fulfilling the need of the present without compromising the need of the future. So the seed being the foundational source of the nature being served as the sustainable development thing, both in present and also in future. And further to move forward, I would like to enunciate the objections of seed patenting into two major criteria. The first being the traditional and stigmatized restrictions, and second being the legal objection and restriction for the seed patenting. So while observing the traditional and restrictions, we can that the plant and product of plants are considered to be the fruit of nature, product of nature. We do have certain moral claim among claiming the private rights over such goods and such products. And the second thing is the introduction of intellectual property right is considered to be a bar for the farmers and seed industry utilizing the seeds, using the seed and producing and yielding such seed products. So it is considered to be an objection for seed patenting. And further diving into, as such, patenting of the seeds provide monopolistic right to the particular person, it is considered to be an IP crime morally against the farmers and the society. So these are some of the moral objections for seed patenting we face as per today. And while coming to the legal restrictions, we have certain provisions which clearly bar the patenting of seeds and the patentability of seeds. We have Section 3 Clause H of the Indian Patent Act, which completely bar the agricultural methodology and cultivation methods being patented. And we have Section 3 Clause K, which completely bar plant varieties such as seeds from patenting. So we have these kind of legal restrictions at present regarding the seed patentability. And the another consideration we have to think about the seed patenting is to whom we have to provide such seed patenting. Whether to the corporates who introduce a genetically modified seeds or the hybrid seeds, or to the farmers who have the traditional knowledge and traditional collection of preserving the traditional seeds. This is again an important matter of consideration while providing patents to the seed and the product of the plants. And this particular matter is considered to be against the farmers because they are the actual person who use the seed for cultivation, against the society, against the seed industry, and against the public domain. So, however, we have been facing a greater revolution from such objections to the transformation of intellectual property rights we now enjoy over the seeds. We now have been granting the genetically modified seeds patent. Now we have granted patents for the genetically modified seeds. And for the farmers who have traditional knowledge and traditional collection of seeds have been provided with a geographical indication. So according to my perspective, it is somehow a greater revolution to move forward into the IPR regime of exercising rights over the seeds. So next, while coming to the exact need of the seed patenting, first we have to observe a fact that the farmers who exercise production in the ancient period differs and struggles at the present in a modern area. This is because the knowledge which ancient farmers have over the climate cycle, weather cycle, season cycle, and environment is very absolute in nature, and they gained and uses that nature in their production and yielding. However, at present, we are facing various environmental crises. We are facing changes in climate cycle. We are facing changes in weather cycle. This obviously has a greater impact on the farmers in using that traditional knowledge and cultivating and producing as much as yield they can. So in order to overcome this, the only way we have is to create new innovations, to create technology. One such example is the green revolution we have during the mere independence time of our country. So these innovations comes up with important statistics and come up with important strategy to increase the production of the seeds and the agricultural producing. And another important factor to seed patenting is the innovation cycle. This is because the innovation cycle begins with the creation, then it travels to the IPR protection, again to the innovation and the investment. So everything is considered to be an interlinked band. So we can consider that the farmer's right, society's right, the inventor's right, the seed industry's right as a part of the web, spider web. And the only matter which is connecting all these factors is the exercise of the intellectual property right. And even to move further dimension that how such kind of seed patenting will amount to sustainable development, I would like to clearly enunciate two important examples. So first, regarding the quantity of the production by farmers, and secondly, the time which has been taken for such production. Because as we all know that the traditional seed varieties took a lot of time, even double the time as we have now for the production and proper yield. And the quantity which the production gives is also minimally very less. So if we use those kind of activities now, in appropriate nexus between the growing population as we face today. So in order to overcome all these obstacles regarding the quantity, regarding the food crisis of the global population, so we have to enunciate the innovations, we have to enunciate such improvement of technology, and the only way for using such is...
Ma'am, sorry to interrupt you. You have 2 minutes left.
Thank you for the reminders, ma'am. Also to further proceed, so only the thing we have as a connecting nexus between the rising population and the rising food crisis is the intellectual property right, which gives innovation, which gives incentive for the inventors and creators to create more such varieties. And further to move ahead, we have certain international conventions which support the seed patenting. We have TRIPS and GATT. Fortunately, India being a signatory of both the conventions, these conventions highly emphasize the importance of the search and RSI system, which protects the rights of the farmers in exercising their traditional knowledge. So this is how the process of patenting have been transformed before the adoption of the TRIPS, since the adoption of the TRIPS, and now fortunately we have the Plant Variety Protection and Farmers' Right Act, which has a balancing approach between the obligation of the breeders, between the obligation of the inventors, without sacrificing the interest of the farmers. So thus on the whole need of the society and the farmers has been transformed into such a way, into a pleasant way, by granting the IPR rights to the seeds. And I would like to conclude my complete presentation by providing such recommendations. Also, namely to create a new system of farmers to give an opportunity for registering their patents for the traditional knowledge and the collection of traditional seeds. And secondly, the technological advancement has to be improved in such a manner to promote development and research in the field of seed industry. And it also proposes an amendment in Section 3 Clause 7 of the Indian Patent Act to exclude seeds in order to grant the patentability of the seeds. And finally, coming to the conclusion part, I would like to end this presentation remembering the excellency of the father of Indian Green Revolution, Mr. Mankombu Sambasivam Swaminathan, sir. So finally, I would like to thank the Institute of Legal and Policy Research for granting such an opportunity. And thank you so much. And if the panel of judge and the respective participants have any questions, I'm much obliged to answer the same. Thank you so much.
Thank you, ma'am. Thank you for your insight, knowledge on mapping innovation, patents, and sustainable development goals. To be concluded in one sentence, if I'm not wrong. The next presenter, may I call upon Mr. Dafiul Haq, Mr. Bishwarup Mukherjee, and they will be presenting a paper titled Sustainnovation, where environmental imperatives meet intellectual property rights. They are from the Department of Law, University of North Bengal. I think they are present.
Yes, am I audible?
Yes, sir, you are audible. Up next is Sanigda, yes, Intellectual Property Rights, University Institute of Legal Studies, Punjab, to get ready. Thank you so much. Over to you, sir. Thank you.
Good afternoon, respected dignitaries, respected organizers, and respected audience. I, Dafiul Haq, and my co-author, Bishurup, we are a third-year BA LLB student from Department of Law, University of North Bengal. Today, we are here to present our research work on the topic Sustainnovation, where environmental imperatives meet intellectual property rights. So, my co-author will going to present this presentation. So I would like my co-author to proceed. Thank you.
Thank you, And good afternoon, the respected dignitaries and organizers and respected audiences out here. So today our topic is the sustainability where environmental imperatives meet intellectual property rights. So first of all, we need to understand that what is the term means sustainability. The term sustainability amalgamates two distinct concepts. The first one is sustainable development and the second one is innovation. It represents integrating these two ideas, emphasizing the importance of innovative approaches for sustainable development. Sustainability and innovation converge at the intersection of environmental imperatives and intellectual property rights, addressing the need for ecological balance while fostering technological advancement. Ultimately, the fusion of sustainability, innovation, and IP rights is pivotal for advancing environmental objectives and fostering a sustainable future. Before coming to the green intellectual property and the need of this, you need to understand that what is sustainable development and what is green technology and what is green innovation out here. So basically, according to the World Commission on Environment and Development that needs in our common future, the sustainable development means a development that meets the need of the present without compromising the ability of future generation to meet their own needs. And the meaning of the green innovation is that the green innovation is a form of social innovation focuses on reducing environmental impacts and maximize sustainability out here. Now, uh, green intellectual. So, what is green intellectual property? According to the United Nations Rio Declaration on Environment and Development of 1992, it is stated that the green technology means environmentally sound technologies that protect the environment, are less polluting, use all resources more sustainably, recycle more of their waste and products, and handle residual waste more acceptably than the technologies for which they are substituted. Some key aspects of green intellectual property are as follows: the copyright, the trade secrets, the licensing and collaboration, patent, trademark, and all. So uh, now we are going to talk about the international efforts in promoting green innovation and sustainability. The Convention on Biological Diversity is the international legal instrument for the conservation of the biological diversity, the sustainable use of its component, and fair and equitable sharing of the benefits arising out of the utilization of genetic resources. The convention was opened for the signature at the Earth Summit in Rio de Janeiro on 5th June 1992 and came into force on 29th of December 1993. It was conceived as a practical tool for translating the principle of Agenda 21 into reality with three main objectives. They are the conservation of biological diversity, the sustainable use of component of biological diversity, and the last one, the fair and equitable sharing of the benefits arising out of the utilization of genetic resources out here. Now, the international effort to promote green innovation and sustainability encompasses a variety of initiatives, policies, and collaboration designed to foster bio-friendly technologies and practices, summarized like the United Nations Sustainable Development Goals. It is adopted in 2050, provide a blueprint for achieving a better and more sustainable future. Then the European Green Deal. It is the US ambitious plan to make Europe first climate neutral continent by 2050. Then the Mission Innovation that it is launched in 2050 along the Paris Agreement. It is a global initiative to accelerate public and private clean energy innovation. Now we move forward to the 28th Conference of Parties that is called COP28 and major engagement of India in COP. Basically, in reality, recently in 2023, The 28th Conference of Parties took place in Dubai, UAE, with representatives from 197 countries presenting their initiatives to curb global warming and engaging in discussion of future climate actions. India has actively taken part in the conference to meet our global concerns regarding the climate change. Its major agreements are green credit initiatives. It has been conceptualized as a mechanism to incentivize voluntary pre-planet actions as an effective response to challenge climate change. Then the phase 2 of leadership group for industry transition called Lead IT 2.0. Then the Global River Cities Alliance was launched at COP28, led by National Mission for Clean Ganga, Clean, Clean Ganga under the Ministry of Jal Shakti, Government of India. It highlights the role in sustainable river-centric development and climate resilience. Then now it is time to understand what is the need for green intellectual property, why we need the green intellectual property in our society. Basically, green intellectual property contributes to economic growth and competitiveness. Sustainable technology and green industries represent significance for job creation, economic development, etc. Technological innovation is critical to answer as we move towards a green future. Through its WIPO Green Project, the World Intellectual Property Organization, that is WIPO, has actively supported and encouraged this. Launched in 2030, WIPO Green seeks to encourage adopting and amplifying eco-friendly technologies in the shift to a low-carbon future by catalyzing and accelerating green technology development. Now, the Indian landscape of green technology. In the nation, 172.72 GW of power derived from non-fossil fuel will soon be operated. In addition to the statistics, India has also launched numerous national initiatives to support green technology and innovation, such as introduction of Agni, a program launched by the Indian government, and a mission under the Prime Minister's Science and Technology and Innovation Advisory Council. There have been also other initiatives such as Climate Launchpad 17, the world's largest green company ideas competition that the European Union co-founded. In addition, the National Science and Technology Entrepreneurship Development Board, its NSTEDB, encourages knowledge-based, technologically advanced business that advance eco-friendly innovation.
Sorry for the interruption.
Sorry,
you have left. You can conclude.
Please.
Yes.
Just 2 minutes. Thank you so much, ma'am. The Ministry of Science and Technology launched the National Action Plan for Climate Change. Now, the legal framework governing environmental law in India with sustainability and innovation. The first of all is the Constitution of India, the supreme law of the land. The Constitution of India provides provisions regarding environmental law, Article 48, capital A, 1, capital A, clause G, and Article 21 as well. Then the Water Prevention and Control of Pollution Act 1974, it protects, it is created to regulate and manage water pollution in India. Then the Environmental Protection Act, then the Air Prevention of Control of Pollution Act, the National Green Tribunal Act. This legislation set up a framework to set the National Green Tribunal in our country. In the Wildlife Protection Act, it puts different animals into different schedules, giving them different levels of protection. Then now it is time for the conclusion. In conclusion, say that international legal instruments and organizations must acknowledge the adverse effect of climate change as a severe global emergency. Undoubtedly, such a complex problem can be addressed through the different of green technology, followed by an innovation-based partnership between technology producers and national members of such international legal organizations. Now, I would like to thank my co-partner, the Fuel Hub, and I would like to thank the Institute for Legal and Policy Research to give me this opportunity to present my paper out here. I would like to thank the organization and all the dignitaries out here. Thank you so much, and that's all for my side.
Thank you
Thank you,
so
ma'am.
much. Thank you so much for connecting Sustainnovation, which is a pioneer approach that blends sustainability and innovations in
Yes,
its concept. Thank you so much. Next, I call
Thank you so
upon
much, ma'am.
Ms. Tanigda S. She will be presenting a topic titled Intellectual Property Rights and Climate Change, a study in green patents from University Institute of Legal Studies, Punjab University, Chandigarh. And your time starts now. Up next, Tushi Chopra to get ready. Thank you so much. Over to you. Sanigda? I think ma'am is not responding. Tushti Chopra, are you here? Tushti Chopra?
Yes,
Tushti
ma'am, I'm
Chopra?
there.
Yes, can you please present your paper titled Harmonizing Intellectual Property Rights with Sustainable Development? She's from
Yes.
Nalsar and your time starts now. And I request Bhavana to get ready. Thank you so much.
Thank you, everyone. My paper is titled Harmonizing Intellectual Property Rights with Sustainable Development Goals, a Step for Common Good. So when we talk about the contemporary policy discussions, we find that they are now focusing on how to harmonize and balance intellectual property rights with sustainable development goals. And we find that they both are considered as opposite to each other up till now. And it is considered that if we want to focus on our common future, then both these needs to be reconciled. When we talk about intellectual property rights, we know that they are a key driver of innovation, economic growth, and they incentivize and protect the fruits of human ingenuity. We know that how the intellectual property rights encourage by providing a temporary monopoly, and it encourages innovation, research, development, technological breakthroughs, artistic creations, and brand development, as well as loyalty. We find that intellectual property rights uh, are of different kinds, and different countries have different kinds of laws for protecting these intellectual rights. But when we talk about sustainable development goals, we know that the 17 sustainable development goals, along with its 169 targets, they are a uniform kind of targets, though it talks about common but differentiated responsibility, but the goals are similar, which to be achieved by 2030. We already find that certain countries are trying to escape from these commitments towards sustainable development goals by saying that they will be, say, pollution free, or they'll be able to reduce greenhouse emissions up to, say, 2% by, say, 2070. And India is one of those countries which is making such kinds of uh, escapes that is there. And we find one of the main reasons is that when we talk about intellectual property rights, these countries, especially developing countries, they want to escape from giving recognition to these rights, because uh, we find that movement intellectual property rights are granted, the persons holders of these rights, they are given special protections and monopolies, and it is a commercial exploitation that it leads to. Though we have provisions like, say, compulsory licensing, or during endemic, we can allow relaxations to these rights. Also, the persons holders of these rights can relieve their rights over these properties. But then we find that sustainable development goals, especially when we talk about climate action, we find that there is a conflict between balancing the two. For instance, if I come up with a green technology and if I do not get the IPR protection, then I'm likely to not be encouraged for future developments, as well as others are stopped from using the same. But the cost of these green technologies can be immense, and secondly, like for me to reap the benefits, it would further add to the cost of these technologies, which means that putting our common future at peril. So we need certain like laws, uniform laws that are able to streamline and harmonize sustainable development goals with IPR. We need to have an interdisciplinary approach for the same, which balances societal, economic, political, legal, and environmental interests of the society. And we also need certain persons, such as, say, persons with disabilities or other minorities, to be considered while when we are developing this framework. Also, we need to understand the inequity between nations, and need to understand that though sustainable development goals are calling for responsible consumption, production, equitable distribution of resources, but we find that the countries need to have a balance while they are granting intellectual property rights, and intellectual property right itself does not become a barrier in achieving sustainable development goals. We also need to take we need to provide, say, funds which would can give equitable status to these countries who are far behind the other countries. Also, there are systems such as carbon crediting and like carbon crediting, which can on one hand help the countries which are not able to adhere to the greenhouse emission commitments and sustainable development goals to buy those credits, and on one hand ensure IPRs in their country. IPRs no doubtedly would promote public health, environment protection, cultural exchange, access to technologies, and also promote inclusion and equity. Also, when we talk about sustainable development goals, balancing with IPRs, we also need to take into interest the indigenous communities and the marginal communities, also the traditional knowledge holders and tribals. So when we talk about them, we need to have adequate protection to these, though we find, say, the definition itself of traditional knowledge being different. We also find that
Tushti Chopra,
yes.
Sorry for the interruption. You have 1 minute left.
Okay. We also find these right holders, like the traditional knowledge, like we don't have a proper definition of traditional knowledge. We also find that who are tribals and what area they are living, there is no proper demarcation for certain persons. So that also needs to be clarified. Accordingly, we can reap the benefits of both worlds, that is IPRs and sustainable development goals, for common good, and we must take all the steps for harmonizing and balancing both. Thank you.
Thank you so much, Ms. Tushti Chopra, who have thrown light on sustainable development goals, and even our 2030 agenda for sustainable developing is transforming our world. And also thank you so much for also bringing out carbon credit, which is guided with biochar conferences, global South carbon market conferences, etc. Now I call upon Ms. Bhavana. She will be presenting a paper on title Balancing Innovation and Sustainability, International Environmental Laws, TRIPS, and Green Technology Transfer in India, from Damodaram Sanjeevai National Law University, Visakhapatnam. Over to you. Bhavana, are you here?
Yes, ma'am. Hello
Yes.
everyone, this is Bhavna.
Up next will be Prayansi Desai. Prayansi Desai to get ready after Bhavana. And please kindly check your chat boxes. I am updating who is to be presented next so that you can get ready without wasting time. Thank you so much. Over to you, Bhavana.
Hello everyone, I am Bhavna and I am presenting today a paper titled Balancing Innovation and Sustainability, International Environmental Law, TRIPS and Green Technology Transfer in India. So in this paper, I would like to deal with most important environmental law conferences and what are the provisions which help it and what are the why environmental law failed and also what are the provisions in TRIPS which facilitate and why TRIPS is being abused by the developed countries and what is the law in India, whether it facilitates for green technology transfer or not. So going to what is
Bhavana, you're not audible.
Yes, ma'am, 1 minute, can you give me a gap?
Yes, please take your time.
Am I audible now, ma'am?
Yes, you're pretty much audible. You can proceed.
And also going to what is green technology transfer. As you see, what is green technology? Those are the technologies which don't harm environment, like for example, solar energy and the technology used in electric vehicles and the technology used in promoting energy storage batteries like zinc bromide cell batteries. And next, going to what international environmental law talks about it. And firstly, the word technological transfer was used in UN Conference on Human Environment Stockholm 1972, which was seen as the beginning step. But there, the technology transfer was used to promote sustainable development in marine technologies. And the next important conference is Montreal Protocol 1987, where the effort was to reduce CFCs, and Article 10A says that the party should have access to green technologies or eco-friendly technologies through transfer. And the next important and most important is Rio Convention and UNFCCC 1992. Article 2, which says about its objective, mainly focuses on protecting environment from actions of climate change and also to stabilize greenhouse gases. And in order to do that, we require green technology transfer, which is indirectly inferred from its objective. And also Article 4.5 says that developed countries should promote, facilitate and finance developing and underdeveloped countries for the promotion and facilitation of transfer of green technologies. And also Article 7.2 talks about international coordination between developing and underdeveloped and developed nations for sake of green technology transfer. As you can see in the picture, there is Technological Executive Committee, which is policy arm, and CTCN, which is implementation arm under the head of UNFCCC for promotion of green technology transfer. As you go through, another important thing is Kyoto Protocol 1997, which is mainly focused on reducing carbon emissions. And for the sake of that, there were 3 mechanisms introduced. Among them, the main mechanism is Clean Development Mechanism, where developed nations need to invest in clean development projects, which include green technology transfer. As they don't harm the environment, they are known as clean development mechanism projects. And those clean development mechanism projects help the investment done by developed countries to help developing and underdeveloped countries. This is beneficial to developed countries as they give carbon credits. And next, even though we have the provisions which facilitate green technology transfer in environmental law, we still see that they are not being implemented. So what goes wrong with the international environmental law? As we can see, The non-binding nature of Kyoto and UNFCCC leads to abuse of those laws and get developed nations exemption from those laws. So it's being wrong with there. And next, there is weak enforcement and implementation of environmental law because due to inadequate laws, inadequate enforcement agencies, inadequate finance, and not interested public sector and private sectors, and also the civil society is not being supportive of these. So these are the wrongs which are made by international environmental law. Next, as we proceed with intellectual property rights, I would like to mainly deal with TRIPS. So before the enactment of TRIPS in 1994, the condition was anti-competitive clauses were being abused by the developed countries and they were having their monopoly over this green technology transfer and they were charging a lot. But after the enactment of TRIPS, if you see about the preamble of TRIPS, it talks about the public policy and public interest as main thing and protecting the intellectual property rights in light of public interest and also framing the intellectual property rights of the countries, keeping in mind developing and underdeveloped nations. Also, Article 7 says that socio-economic welfare is of prime importance and balance of rights of producers, developed nations, and utilizers, developing and underdeveloped nations should be balanced. And also Article 8 says that members can frame intellectual property rights protecting public interest in terms of not only health, public health and nutrition, but also in economic and technological advancements. So under this head, climate change would come under the public interest. Article 40.1 and 40.2 says that patent licensing should not be abused by developed countries. Article 66.2, which is considered as very important article, which facilitates that technological capabilities can be transferred to least developed countries by developing and developed countries, is one of the most important article. Even though we see those articles promote, but still we have some debatable issues in the IPR law. The main debatable issue is patentable criteria. As you know, for patent, we require novelty in invention, and inventive step or non-obviousness, and industrial applicability. These are being rigid things, and developed countries call them as minimum protection standards and won't allow the patents.
You have 2 minutes left. You can have a bird eye view on your presentation. 2 minutes left. Thank you.
Yes, ma'am. Due to the rigid patentable criteria, the developing countries are not able to obtain patents, and they argue that under the public interest, we require climate change to be taken as public interest and facilitate this, and exceptions of patenting granting, as said in Article 27.2, which says that if an invention or technological advancement is against to public order or morality, and it affects the human life, animal life, or environment, and it should be granted exception under patent granting under 27.2. This clause is strictly being interpreted by developed nations that it should be only done in the light of it is not a public interest or it does not violate public order or morality, as climate change does not do. But developing nations say that they do, and compulsory licensing is a criteria where government does not take the consent of patent holders and grants patent licensing to other countries for manufacturing, selling, or importing. It is seen as a step of degrading the IPR rights, whereas the present IPR regime does not support developing countries. As you can see, it suppresses the local innovation. You can see that patent rights, patentable criteria is strict. So every country does not have adequate IPR regimes in form of TRIPS, as every country's R&D is different, finance is different, technological capabilities are different, and also there is being abuse of patent rights. So what are the ways to solve this? As you can see, there are substitutes for patents. Article 29.1 says that patentable information should be disclosed through which substitutes can be developed and it can be used. This does not violate patent law. And also for compulsory licensing, there need to be inclusion of a clause known as whenever those circumstances which affect public interest are being used, Ma'am,
Dr.
one more minute, ma'am.
Yes.
One more minute.
1 more minute granted.
Yes, ma'am. Like whenever this circumstance end, it need to be ended, and reasonable compensation should be provided to patent holder in form of judicial assessments. And also there are patent pledges, patent pools, and also there need to be some of the changes done to the patent law. And also eco patent comment should be platform can be used. And also regarding Indian law, you can see Indian Patents Act section 3B and section 47 subclause 4 and section 84 1A 1B provides for compulsory licensing, and that there should be no commercial exploitation in such patents which promote climate change. And finally, the environmental laws also promote, Indian environmental laws also promote. Finally, I would like to conclude that the requirement is not also change in laws, and also the mindset of developed countries, and Indian laws facilitate EST's transfer. Thank you, Institute of Legal and Policy Research, for providing me this opportunity.
Thank you, Bhavana, for throwing light on various facets of greennovations, intellectual property, eco patents, etc., which is of new concept. Thank you for your insightful knowledge on all these aspects. Now I call upon Ms. Preyansi Desai to present a paper titled Orchestra of Sustainable Innovation for Preserving Nature's Treasures, the Nagoya Protocol, from the Maharaja Sayajirao University of Baroda. Over to you. Up next will be Vasavi Murugan. Please get ready.
Am I audible?
Yes, you're pretty much audible. Please start.
Yeah. Good evening, everyone. I'm Preyansi Anand Desai from the Maharaja Sayajirao University of Baroda, and I am here to present my paper on the title An Orchestra of Sustainable Innovation for Preserving Nature's Treasures, the Nagoya Protocol. The Nagoya Protocol was adopted on the 29th October 2010 during the COP10, that is the 10th meeting of parties, and it was ratified on 12th October 2014 by 130 countries in Nagoya in Japan. The protocol impacts sustainable innovation, focusing on equitable benefit sharing and access to genetic resources. It also helps to illustrate the relationship between IPR and the traditional knowledge, and it is an addition to the Convention of Biological Diversity. Further, there are certain goals of this protocol which can be addressed as it helps in exploitation of genetic resources without compensation to biodiversity rich countries. It provides access to genetic resources by creating legal framework for access under mutually agreed terms between the party nations. It provides methods and tools to reduce pollution, conserve energy, and preserve natural area. The protocol also helps in the implementation, and its implementation actually varies from country to country depending upon their own challenges, which may include the challenges in funding, the challenges of the use of the technology, and the challenges in capacity building. It ensures fair distribution of the royalties received from the grant of intellectual property rights and other non-financial benefits such as the capacity building. It uses various checkpoints and national focal points to for monitoring and regulating regulating its rules and regulations within the member states. Helps in creating jobs and promotes green sector growth because it is measure promote sustainable innovation. It addresses inequality, health, and education for social benefits, and it also compliances the measures for maintenance of access and benefit sharing rights between the member nations. Now, the question arises as to what is sustainable innovation. So, sustainable innovation can be defined as the introduction of new goods, services, technologies, or businesses that reduce the environmental and societal impact. And there are various methods which are involved in sustainable innovation, such as it includes the drugs derived from genetically preserved compounds. It helps in introduction of the novel crop varieties resistant to pest, diseases, and climate change. It also introduces the development of biofuels and environmentally friendly methods in the biotechnology, and it helps in making cosmetics which are made from the natural ingredients that lead to a safer and eco-friendly product system. Now we move on to the different challenges that the protocol hampers on being three major challenges of the protocol. The first one being the complexity of legal framework, because we already know that the intellectual property framework in itself is not very dominant as a legal faculty. And secondly, the awareness and participation of local and indigenous communities is a must under this protocol, because it ensures that genetic resources are used and also the traditional knowledge is used and is transferred further in the development of intellectual property rights and the development of the country's growth and economy. Third challenge would be the monitoring and enforcement across various jurisdictions, because we are very well aware about the state that the international conferences and convocations do not have a varied binding force on the states. So these are the major challenges. Now, where there are challenges, we can also see that there will be opportunities for this protocol to be implemented in the party nations. So I would like to enlist three major opportunities, which can be: it helps in enhancing the international cooperation and capacity building among the member nations. Second would be, it helps in encouraging sustainable innovation through legal frameworks. Now, this can be done when all of the municipal laws incorporate the intellectual property framework, and also gives the measures to protect environment along with granting intellectual property rights to the authors and the owners. And this will be regarded as the best boon for the 21st century. The third opportunity that this protocol gives the member nations would be the improved benefit sharing mechanisms, in which majorly the role of traditional knowledge comes into place, wherein the traditional knowledge can be used by one country to help in the development of the other nation countries. For example, the turmeric of India, which is used for varied health benefits, is now used worldwide for the same. So these are the probable opportunities that the protocol brings with it. Now, since it is about, the theme is about the intellectual property and the environment law, we can now move on to check about the intersection of the intellectual property rights with the Nagoya Protocol. So it develops the complex relationship between patents and genetic resources, because they mainly help in
interruption. You have
Yes,
2 minutes
ma'am.
left. Thank you.
Yes, ma'am. Yes, ma'am. So it basically develops relationship between patents and genetic resources, which are majorly used for pharmaceutical and health products. Then it also requires the disclosure requirements that ensure that the compliances of the protocol are met with. So intellectual property is majorly based on contracts and written agreements. So if you want to comply with the protocol, and if we want to improve our traditional knowledge use, we also need to have disclosure requirements. Thirdly, it protects and integrates the traditional knowledge with the IP system. Finally, to conclude, I would propose future directions of the use of this Nagoya Protocol. Although the Nagoya Protocol is full in itself, it is not properly used by the countries. Hence, we need certain steps to use it very effectively. According to me, these will be the three steps that we can implement to get better results after the Nagoya Protocol. The first would be strengthening regulatory frameworks. Second would be enhancing public awareness and participation. And the third would be fostering sustainable development and biodiversity conservation. Thank you.
Thank you so much, Ms. Priyansi Desai, who have thrown a light on Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits, which is arising from the Convention on Biological Diversity, if I'm not wrong. Thank you so much for your insightful presentation. Now I call upon Ms. Vasavi Murugan. She will be presenting paper titled The Interface Between Intellectual Property and Sustainable Development in International Environmental Law from Government Law College, Chengalupattu. Over to you.
Ma'am, are you audible, ma'am?
Yeah, you should be audible. Yes, you are audible. Up next will be Dr. R. Gomati Shankar. Please get ready along with Papiti. Get ready, please. Thank you so much. Over to you, Vasavi.
Yeah, ma'am. I call Yasavi, ma'am, not Vasavi, ma'am.
Yasavi.
My name
Okay,
is
Yasavi.
Yasavi, ma'am.
Yeah.
Yes, ma'am.
Yes.
Good evening, ma'am. My topic is the interference between intellectual property and sustainable development in international environmental law. First of all, sustainable development has emerged as a key priority in the global agenda, and the intellectual property systems has come to interact more closely in this. There is a sustainable development between the IPR and the environmental law, such as legal policy and legal issues in the IP system still is grappling in relation to such as biodiversity, climate change, and the diffusion of green technologies, food security, implementation of the sustainable development goals more generally. So in this article, especially emphasize about the sustainable development in IPR and the environmental system. At the intellectual property and the developmental issues re-emerged in the year of 1990s with the adoption of the agreement on trade related aspect of intellectual property rights. That means TRIPS agreement is ensuring the debate on the patent and public health resulting in the Doha declarations on TRIPS and public health 2001. And with the WIPO development agenda 2007, the role of IP and the impact on social and economic development was the heart of this debates. In the year of 2030, Agenda for Sustainable Development was adopted within the 17th Sustainable Development Goals. It is a very important goals in this throughout the world. The chapter main aims to provide overview of the interference between IP and sustainable development is an economic and social environmental issues challenging to address within the framework to sustainable development of the IPR and intellectual property and the environmental law. Sustainable development and intellectual property rights means the last debate of the past century. Sustainable development are emerged as a central concern in the global agenda. The Bern Laws report from the year of 1987, our common future is the most widely accepted definition of sustainable development, but till a date the sustainable development to achieved in the year of 2030. The United Nations Conference on Environment and Development, UNCED, also known as the Earth Summit, held in Rio de Janeiro, Brazil in June 1992. It is a key word to mark in the recognition of sustainable development is transferred in the series of Agenda 2118, 218, and the Rio Declaration and the environmental development. This is a major development for the environmental system, such as Earth Summit, and also a Convention on Biological Diversity, United Nations Framework Convention on Climate Change. This is the major role to provide and sustainable development of environmental protection, and also intellectual property rights in sustainable development fora. For example, transfer of green technologies is a sustainable development in the IPR system. In the year of 1992, promoting the transfer of environmental sound technologies, that means ESTs, to developing countries to Central Cancun at Earth Summit. Under the Earth Summit, Chapter 34 of Agenda 21 was entirely devoted to the transfer of EST and included general provisions of IPR. The Convention on Biodiversity also addressed the issue of IPRs under Article 16, Clause 5 of Convention of Biodiversity states that contracting parties recognize the patent and other intellectual property rights may have influence of the environmental law. So overall reference of the IPRs in Agenda 21 and proved the controversial status in their society. After that, the technologies development is growthed in the intellectual property system. Artificial intelligence is a major role played to a IPR system. The sustainable development in intellectual property agreement and fora in the year of many development, since similar to IPR presents very development in the IPR. So World Trade Organization and World Intellectual Property Organization, two keywords pillar of the intellectual IP system. In recent years, IP provision is bilateral and regional free trade agreement have also become a central part of global IB system. First of all, what is meant by World Trade Organization? World Trade Organization is between the nations to trade, one nation to another nation between trade. The negotiation is urgently round to the establishment of WTO in the year of 1994. As a result of the preamble of the agreement established, the WTO makes specific reference to sustainable development as is mentioned in the state, allow for the optional use of the world resource in the objective of the sustainable development. The main aim of this preamble is the sustainable development of the IPR system between the World Trade Organization, one country to another country. So extensive discussion on the sustainable development relates issues such as public health, biodiversity, and climate change, has taken part in the Council for Trade-related aspect of IP rights. And since it's established, a consequences here in the Doha Declaration of the TRIPS Agreement and Public Health in the year of 2001. It is a great changes of the sustainable development of World Trade Organization. Next one is World IP Organization. It means contrary to the reference of the sustainable development, may broadly not a feature of original mandate. It is a 1961 convention established the UN specialized agencies in the 1974. So it is a technological invention, science and creativity activity, general and rightly recognized important sources of to achieve the poorer people also achieve the sustainable development in the world. So IPR rights is as well as copyright, patent, so many trademarks. These are the comes under the intellectual property rights. Next, they have another major area of WIPO, World Trade Organization, and also World International Patent Organization work is related to sustainable development to a issue at the Patent Law Treaty Diplomatic Conference in the year of 2000 was established a forum to discuss IP issues and related matters. Next, we are going to free trade agreements, IP and sustainable development.
Vasavi Murugan.
Ma'am?
Sorry for the interruption. You have 2 minutes left.
Okay, ma'am. Okay, ma'am. Chapter 23 of the CPTT on development emphasize the parties may enhance the broad-based economic growth only focus of this sustainable development and advantages of the trade investment opportunity creators between the agreement World Trade Organization. It is a greatly sustainable development of the world. As the free trade agreement means IP matters related to genetic resources, traditional knowledge, have also included. I conclude this article with this: a sustainable development is both IP laws and international laws as interconnected between the environmental law is Earth Summit, Rio Declaration, as well as, and the IPR is a World Trade Organization and intellectual aspect of Wipro. This is all a protection of the IPR laws, ma'am. And
Thank you.
also nowadays IPR is a more efficient and knowledgeable person. So AI is nowadays AI is also a IPR, one of the subject of this IP system, ma'am.
Thank you so much, Ms. Yasavi Murugan, for your
Thank you, ma'am.
presentation, which was on sustainable development, wherein you have thrown light on Earth Summit also and taking all the aspect of traditional and updated AI concept into consideration. In a nutshell, you have presented in a very brief note on your topic. I now call upon Dr. R. Gomati Shankar ML and Papati K for their presentation title, Judicial Activism under Environmental Law. Assistant Professor, Faculty of Law, Dr. Magar, Educational and Research Institute, University. Over to you, sir. After Sir Priyanshi Jain to get ready, I have already updated the same in the chat as well. Thank you so much. Over to you, sir. Sir is here. Gomati Shankar. Okay, we'll move on to Priyanshi Jain. Priyanshi Jain is present. So Gomati and Priyanshi Jain is not here. Shrimati ma'am is present. Shrimati. Miss Shrimati S.
Ma'am, I
Miss
have
Shrimati
already
S.
done with my presentation.
Okay, Miss Shrimati S has already done with the presentation so much, but it has been here in the list, so I called you. Miss Tanvi Kandolkar and Miss Varsha Redkar. Are you people here?
Ma'am, if it's okay, can I go ahead with the presentation? I am scheduled last at 5:50 p.m.
No, let me call upon the names. If they are not there, we'll be providing them opportunity at the last. So Tanvi and Varsha is also not here.
Excuse me, ma'am. Can I know the Varsha V or some other thing?
Varsha Redkar, Miss Varsha Redkar from VM Salgokar College, Goa. Varsha V.
Yes, ma'am. I'm Varsha V from the Tamil Nadu Dr. Ambedkar Law University, ma'am.
Okay. So
You can
Rani,
proceed, ma'am, no problem. Instead of another Varsha, you can go.
Rani is here. Rani.
Yes, ma'am, I'm here.
Yes,
Yes, ma'am, I'm
Rani.
here.
Varsha can present now, followed by Rani Sangamitra. So Varsha and Rani Sangamitra will be presenting now. Thank you so much. Varsha, over to you, and your time starts now.
Yes, ma'am. Greetings to one and all present here.
Varsha, you are not audible. Please unmute and speak.
Can you hear me, ma'am?
Yes, now you are pretty much audible. Please proceed.
Yes, ma'am.
Varsha? Without any further ado, I call upon Rani Sangamitra to present a paper
Yes,
titled.
ma'am. Am I audible?
Rani Sangamitra?
Yes,
Am I
you are
audible, ma'am?
Yes, you're pretty much audible. So Rani Sangamitra will be presenting a paper titled Synergizing Geographical Indication with Rural Development and Biodiversity Conservation from the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. Over to you, Rani. Your time starts now.
Yes, ma'am. So my presentation deals with challenges and geographical impact of GA on biodiversity and rural development, policy frameworks. It includes TRIPS, WIP of WIPO and GI Act 1999 of India and GI tax in India. So in general, Gucci mushroom from Jammu and Kashmir has got GI tag recently. As of July 27, 2022, 420 registered GI applications are in India. 21 European GIs prioritize rural development. As per the government data of India, 167 products enter GI market between 2023 and 2024. They are all the GI products of India. So it's around 643 now. So coming to the challenges that GI face in India are complex registration process, which the poor or rural farmers could not access. Pending application, there are several pending applications in the GI registry of Chennai. Several hurdles are faced by the rural producers in making investment. Their procedures are difficult. For me,
Rani, you're not audible. Miss Rani? Rani? I think Rani has lost the link.
Okay, we can move for the next presenters, ma'am.
Yogita, you're here? Yogita, I can see you here.
Yes, ma'am. Yes, ma'am.
Even I can see Varsha and Tanvi also here, but they're not responding. I have mailed it in the chat box. Anyways, Yogita.
Ma'am.
Yes, Rani.
Yogita gone and yes,
Am I
Nita.
audible now?
Yes, ma'am. Yogita and Nesmita are present.
Ma'am, am I audible now? Ma'am, am I audible now?
Rani, you can present it at the last or after Yogita. Now, without wasting time, we can proceed with Yogita and Nita's presentation, which they will be presenting title Green Energy Revolution from Pendenkanti Law College. Over to you, Yogita. Yogita?
Yes, ma'am.
Please start your presentation. Tasneem Jahan is there?
Yes, ma'am. I'm here.
Tasneem Jahan, you will be the next presenter, so please get ready.
Okay, ma'am.
Thank you so much. Yogita, over to you now. You can start.
Good evening, everyone present here. Our topic is green energy revolution. So let us understand why this topic has been immersed. Due to the over pollution and the over utilization of natural resources, the green energy revolution has been immersed in this in all over the globe. The fossil fuels like coal, gas, oil, and are the largest contribution for climate changes across the globe, accounting 75% of global gas emissions and nearly 90% of carbon dioxide emissions have been introduced. To avoid this worst impact of climate change, the emissions have to be reduced by half by 2030 and reach net zero by 2050. To accomplish this goal, this need to be discontinue our dependence on fossil fuels and allocate resources towards accessible, cleanable, affordable, sustainable, and reliable alternative, that is renewable energies. The concept of green energy revolution includes renewable energy. So renewable energy refers to the energy obtained from natural resources that are replenished at faster rate than their consumptions. Around 29% of electricity presently comes from renewable sources. The International Renewable Energy Agency estimates more than 90% of global electricity can and should be coming from renewable energy by 2050. First, let us know what is solar energy. Solar energy is where we use sun and convert into thermal or electrical energy. Solar energy is one of the richest sources used in US. Solar energy is one of the energy which is almost used by all across the countries. So the solar technology can harness this energy for a variety of these uses, like generating electricity, providing light, heating water for domestic and industrial use. though there are so many advantages of solar energy, there are as well as flaws in solar energy. There is storage expensive. Initial installment of installation of solar energy is expensive, and also it's high. We do not have sun all the day long.
The next energy we are going to talk about is the wind energy. The energy which is created from the wind is called as an wind energy. The kinetic energy of the air is converted into electricity by the use of turbines and the windmills. The blades rotate and they create a kinetic energy which is then converted into the electric energy, which can be used in different forms, such as for electricity and also as a fuel. And the total wind turbines around the world produces 2,100 terawatts of electricity per hour in a year. And there are many countries which are seeing it as an future of the energy, as there are many countries which are located in the hilly areas. This energy is great as a renewable energy, but it has its own flaws. One of few of their flaws are the wind mills cannot sustain the harsh temperatures such as cyclones and tsunamis. They might get destroyed in those natural disasters, which might take a long time for them to recover, and also this will increase the budget of the company. The wind turbines will also create the noise pollution to the people living over there, and will also disturb the animals which travel by the sound. And it will also disturb the natural flying habitat of the birds, such as eagles and other migratory birds, which follows a certain migratory path. The next energy would be the biofuel. The biofuel is the energy which is derived from the biomass, such as plants, algae, and the animal waste. The waste is collected and then it is put into a tank-like structures called as digesters, and then all the waste is being reacted with microbes are introduced to it, so that they will go through the process of digestion. There are two types of digestion: aerobic and anaerobic digestion. Aerobic digestion, which takes place in the presence of oxygen, and it releases the largest amount of carbon dioxide, and anaerobic digestion, which takes place in the absence of oxygen, which releases carbon dioxide as well as methane. And the carbon dioxide and the methane, both are the products which can be used to generate the electricity. The methane which is generated would have the more effect than the carbon dioxide, as it can produce it has a greater energy frequency than the carbon dioxide. There are many different people who have been using this biofuel as the energy, not only to their homes but also to the other homes in their surroundings. Such as in France, a man named Maurice Quack have been using this anaerobic digester and have till now produced 13 gigawatts per hour. And in Brazil, this country have done an excellent been excellent in using this biofuel. During the 1970s, as there was an oil crisis all over the world, this country have turned its eye to the sugar cane, which was available quantitatively in their country, and their country was having more sugar, and there was no and not sufficient demand for it. So they converted the sugar into the energy called as into the fuel called as an ethanol. In that way, the biofuel is divided. The biofuel is processed. The liquid from the biofuel can be used as ethanol or biodiesel. The ethanol is the purest form, and after refining it, will get the byproduct as a biodiesel. And the slurry which is remained from all this process would be used as a fertilizers, which would in turn help our environment without any further impact on this environment. India have also been using this biofuel, and currently we have been using 10% of ethanol mixed with the petrol to reduce our dependence on the petrol, and successfully we have done it. And by 2025, our government have decided to mix the petrol with 20% of ethanol, and they have even succeeded it before the time limit. And currently, since the 2024 April 2024, we have been using E20, that is ethanol, petrol mixed with E20, 20% of ethanol. This process have reduced the pollutant successfully. And the only problem which rises out of this biofuel is that it increases the food and water scarcity, and as it uses those as an ingredients to produce it. So coming to the conclusion of our paper, in this paper, we have discussed about the main important energies which have been researched about, and there are many other energies which have to be, which needed more study, but we have chosen only the energies which were reliable. And embracing the renewable energy is the only source, as it is not only contributes to the environmental preservation, but also boosts our economy, and also promotes the social well-being. There are many and other energies which needs to be progressed, and this study of these energies would be a win-win situation for both the humans and the environment. So I feel this would be the greatest opportunity for us to develop more about these energies and to study more about these energies. This sector also plays an important role in improving the life of the people, as it provides the employment and also protects the environment against the fossil fuel energy which we use currently. And it is sustainable and is prosperous for our future generations to come. Thank you.
Thank you so much, Ms. Ye Yogita Gond and Yes Nita. We did not see Yes Nita speaking.
No, ma'am. First, she was the one who came up.
Okay, you have thrown a light on green energy revolution. Thank you so much for your insightful presentation on green energy revolution, its pros, its cons, and also its future implications. Now I call upon Tasneem Jahan. Ma'am will be presenting a paper titled Homogenizing Traditional Knowledge and Biodiversity Conservation, a study intersecting IP rights and sustainable development, from the School of Law, Merces, Bangalore. Over to you, ma'am. Before ma'am begins, let me tell you, there was one request from a person by name Swastika. Swastika is here. Is Swastika in meeting?
So yeah, she's here. She joined.
Swastika, after Tasneem Jahan, you have to get ready.
Am I audible?
Yes, you are audible, Swastika. Tasneem Jahan will be presenting the paper because I have given her time now after Yogita. So after ma'am's presentation about 10 minutes from now, you please get ready and please introduce your topic also. Okay, thank you so much.
Okay.
Very good evening to the chair. I'm Tasneem, and my paper, as informed by the chair, Homogenizing Traditional Knowledge and Biodiversity Conservation, a study intersecting IP rights and sustainable development. And as you can see, there are various components right here, which is kind of being talked about, because the very title of the webinar is interlinking environment, sustainability, and intellectual property right. And hence the topic that I have chosen is something that is creating the link between the traditional knowledge, which is a non-conventional form of intellectual property rights, and the biodiversity conservation, whose very idea or very importance of the legislation is to preserve environment and promote sustainability while we enforce the IP rights. So we have seen that we have literally seen that in our generation, or currently government or as a nation, we are promoting more and more intellectual property rights management, asset management. So because as any other property, intellectual property is also an asset which can be sold, promoted, sold, or it can be increased in order to create our reputation in the market, or give an advantage setup in a given competitive advantage. Okay. So because of this, a lot of effect is something that is kind of having an impact over the environment in general. So this paper is looking into two aspects. Firstly, what is this biodiversity conservation, what is intellectual property rights, and how it is intersecting that can promote environment sustainability. So firstly, I'll start with intellectual property asset management. So the concept of intellectual property asset management is a concept which centers around identifying data, organizing, transforming into information that may be useful to form a part of knowledge bank of any organization and become an asset. Once it has become the asset, these are the collection of various intellectual properties such as patents, trademark, copyright, industrial design, geographical indication, etc., that can be strategically chosen for their business value depending on what kind of business the company is trying to set it up and what kind of competitive advantage it wants to gain for its company. So managing such intellectual property asset carefully and in a strategic manner that maximizing its value is the key to generate wealth for that particular company. So basically, intellectual property asset management is a modern day management system which manages not just the tangible property but as well as the intangible property in form of IPRs. So in IPR also, whenever we talk about IPR, the very common IP that comes to our mind is patent, copyright, trademark. So these are the conventional forms of IP. So apart from these, we also have non-conventional forms of IP, which is traditional knowledge, which is geographical indication for that matter. So this particular paper talks about the traditional knowledge, those indigenous knowledge that is available with the very local or the indigenous people, and they are the actual providers of these particular traditional knowledge. And if this is what do you say, if IP rights are attached to these particular property, then these are taken as an asset for the company or for the government or anyone for that matter as a stakeholder. So what happens once the intellectual property asset management is going cross this and moving to traditional knowledge? Okay. So traditional knowledge, according to the World Intellectual Property Organization, is something like a living body of knowledge that is developed, sustained, and passed on from generation to generation within a community, within a community, often forming parts of its cultural and spiritual identity. The very basic example of one of the traditional knowledge can be mangroves. Like generation after generation, people, the community people are taking care of this mangroves, and not even government sometimes dare to get into or interfere into that. So similarly, some living body of knowledge that is developed over a period of time and that is passed on from generation to generation within a community. Okay, so this forms a spiritual identity that is available with them. So this paper is actually talking about how when these traditional knowledge are gaining an intellectual property status or government is protecting it through different laws and conventions and conservation system, what is this indigenous people actually getting? Now, what is the idea? Why I'm talking about the rights of the indigenous people here? Because if there is a benefit sharing system for the indigenous people, that will be not just helping the indigenous people or the local people, but also the environment as well, because these are the people who are actually aware of these traditional knowledge and how this has to be used so that this doesn't get exploited. Because the people or the government or any other stakeholders which is taking care of these, they are not the ones who have lived with traditional knowledge. Okay. So this was the second concept, the traditional knowledge. Third, I want to talk about the access and benefit sharing provision that is provided under the Biological Diversity Act 2002. So India ratified the Convention for Biological Diversity 1992 in the year 1994. And after numerous consultations and meetings and changes, it was finally enacted in the year Biological Diversity Act 2002. Modified the rules in 2004 to give effect to the provision of the CBD, including those relating to its third objective on access and benefit sharing. Hereinafter, in this paper, it has been referred as ABS system, which specifically talk about how this indigenous people should be having access to this traditional knowledge and how there should be benefit sharing provision for these people as well, because this will not only help them but also the environment together. So this is the third aspect. Fourth, the paper that I've submitted, it also talks about how there is a link between it and are the people actually aware of this provision, the indigenous people. So the researcher, me along with my co-author, we tried to interview few of the indigenous people and the local people of mangroves and other traditional knowledge area. So we trying to find out if they were actually aware of such a system, firstly, because IP is, again, though it is an old concept by now, but a lot of local people or for the layman, it's still a new concept. And especially the non-conventional forms of IP are actually very new concept. So first question that was asked was regarding, just a minute, I'll just scroll. Yeah, first question that was asked was, are you aware of the Biological Diversity Act, first of all? So out of 72 people that we actually tried to talk to, only one was actually aware of that there is some act which is actually dealing with the diversity act, Biological Diversity Act. 71 were unaware. Second question, are you aware of the Biodiversity Management Committee in an area? All 72 were clueless. Thirdly, have you been contacted by the Biodiversity Management Committee of your area? Again, all 72 were clueless. Ki no, we are not aware of any such committee in our area, and none of us have ever contacted us regarding any of these rights. So why is the situation that they are not aware of it? Because if they're aware, then there has to be given certain benefits in the traditional knowledge that is now protected by the government as well. So there is a big gap with respect to the awareness for traditional knowledge and benefit sharing for the local indigenous people. So what this paper wants to highlight is that it is very important to just understand that the objective, the very much objective of the Biodiversity Act 2002 is not trade oriented. It's not something to delve more into the IP rights and benefits arising in it and using it for the competitive advantage, but conservation and sustainable development oriented. And that's where the intersection begins of intellectual property rights, environment, and sustainability, which this particular act, Biodiversity Convention 2002, which actually talks about the provision of benefit sharing is totally voluntary in nature. Its main focus is never on reaping the commercial benefits, but the aim is that it shall provide access to the biological resources and associated is permitted, and any IPR is generated on its property to provide it to both the indigenous people, the government, the stakeholders, as well as the environment in general. So with this, I would just like to, on a concluding note, I'll just conclude that CBD 1992 is a very good piece of legislation, but there is certain gaps that needs to be filled in order, because provision is already provided there and a voluntary provision is there. But as long as people are not aware of it, whether the regional, the indigenous people or us in general, so this provision, the voluntary provision, won't be of any help, and the environment sustainability that we're talking with respect to the intellectual property rights, that might not reach that length that the act is supposed to get to. So with this, I would like to conclude my paper. If there are any question, I would like to answer that.
Thank you so much, Ms. Tasneem Jahan, for giving an insightful knowledge on homogenizing traditional knowledge, along with your approach, which is, of course, doctoral in nature with a limited fragmentation of time. Now I call upon Swastika Kadeswaran to present a paper titled Addressing Fragmentation of IPR and Environmental Law.
Thank you, ma'am.
Yes.
Over to you now. Swastika?
Ma'am, is my
Let me check over. Yes, it is buffering, but it may come. You can start your presentation.
Yes.
Before the screen comes, let me just confirm whether Nanda Lingareddy is there from Bellary University. It's not there. Varsha?
Yes,
Rani
ma'am.
Varsha and Rani Sangamitra to get ready after this presentation. Please get ready. Thank you so much. Over to you now.
Yes, the screen is visible now.
Yes. Fragmentation, intersection. Yes, it is visible. Pretty much visible. You are a student of BA LLB, I think. You
Yes,
can
ma'am.
proceed.
Yes, ma'am. My warm greetings to one and all present here. Myself, Swatika Kadishwaran, pursuing third year BA LLB in School of Excellence in Law. Today, I am here to present on the topic addressing fragmentation, the intersections of intellectual property and environmental law. Starting with the introduction, it represents a crucial and a critical challenge for the innovation and ecological sustainability. As intellectual property rights are increasingly intersect with all the environmental concerns, and it sometimes also has some conflicting objectives which becomes imperative. This fragmentation, which will demand a comprehensive approach that harmonizes the legal framework to incentivize the innovation while ensuring the environmental protection. Bridging this gap will require a more interdisciplinary approach and collaboration to develop more sustainable policies. So by integrating environmental considerations into the intellectual property laws, IP laws, and fostering cooperation between the stakeholders and policymakers can regulate and create an environment that encourages sustainable practices and responsible innovation. So effective governors in this realm must navigate the complexities and trade-offs, prioritizing all the long-term health of the planet alongside the complexities. So now moving on with the comparison of intellectual property and environmental law, IP law is mainly deals with the protection of creation of minds such as inventions, etc. Whereas environmental law focuses on regulating the human activities. IP laws have a globalized impacts and environmental laws have localized impacts. IP laws covers intangible assets like copyrights, whereas environmental law deals with tangible aspects regarding and regulating the human behavior, maintaining the natural resources, etc. It incentivizes innovation and creativity by granting exclusive rights to the creators and inventors, whereas environmental law regulates human behavior to prevent harm and promote sustainable practices. IP rights can be enforced through legal mechanisms such as litigation, licensing, and injunctions. Environmental law often involves the regulatory and compliance monitoring penalties for non-compliance. The main basis of fragmentation, why there is a fragmentation between this intellectual property and environmental law, is because of diverse national laws. We have different territorial laws over different territories and complexities within the IP rights, which often leads a layman with more confusion and disputes. Rapid technological advancements, which is been not still reached the people who are residing in more remote areas, jurisdictional variations, and lack of integration of interdisciplinary perspectives. Ma'am, is the screen visible?
No, the screen is not visible, but you can continue. Later you can share. Thank you so much.
Oh, now, ma'am? Ma'am, now can you please confirm whether it is visible?
It's not.
Oh, okay, ma'am. Just a minute.
No, you can continue. Please continue. You have 6 more minutes left. You can continue.
Oh, okay. So it requires a lack of integration or interdisciplinary perspectives also will hamper this environmental law effectiveness, which often leads to different stakeholders. different stakeholders have conflicting and the fragmentation, which fragmentation undermines the effectiveness of both legal domains in addressing the global challenges. The major case studies have taken are as Indian Performing Rights Society Limited versus East India Motion Picture Association. So here in this case, it addressed the issue of copyright protection for environmental sounds, which specifically introduces the recorded songs of birds in a film. The Indian Performing Rights claimed that the incorporation of recorded bird sounds constituted a public performance or copyrighted material, which require a payment of royalties also. So this case is set as a precedent for protection of intellectual property rights in environmental context, which recognizing the value of natural sounds and their commercial use in creative works. Followed by Velur Citizens Welfare Forum, this is Union of India, 1996 case law. So in this landmark case, the Velur Citizens Welfare Forum filed a PIL, a public interest litigation against the industrial pollution in Velur, Tamil Nadu. The Supreme Court of India addressed the various environmental issues, which included the contamination of water bodies by industrial effluents, air pollution from industries, and health hazards. So the court issued the directives to regulate the industrial pollution and protect the environment, emphasizing the importance of precautionary principle, where the polluter pays principle was being introduced. Here, the case highlighted the judiciary's role in environmental protection and set the legal precedents for enforcing environmental regulations and holding polluters accountable for the environmental harm. So I would like to conclude by stating that addressing the fragmentation between IP and environmental law is a paramount for achieving the sustainable development and fostering the innovation, while safeguarding both the planet ecosystem as well as the development. By harmonizing the legal frameworks, enhancing the cross-disciplinary collaborations, making the remote areas more developed, integrating environmental considerations into IP policies, the policymakers can also promote coherence and effectiveness in the governance. So, through proactive measures such as stakeholder engagement, capacity building, adaptive governance, it is possible to bridge the gaps between IP and environmental law, ensuring the legal mechanisms. So, through those concerted efforts to address fragmentation, we can navigate the complexities of modern world and uphold the principles of sustainability and justice. So I would like to conclude my presentation stating that from fragmentation to integration, a sustainable legal future. Thank you for the opportunity. If any questions, ma'am?
Thank you so much, Swastika. If any other participants have questions, they can put it in the chat box addressing to which participant you have been put your question with, and what are the issues, what are the doldrums you were having in your mind relating to their presentations. You can put in the chat box and you can address the same to either topic or to the concerned person, so that it will be taken up at the last for 5 minutes. Now I call upon Ms. Tanvi Kandolkar and Ms. Varsha Redkar for their topic to be presented, titled Fragmentation and Synergy, Exploring the Intersections of Intellectual Property and Environmental Law. Assistant Professor of Economics and Assistant Professor of Law, V.M. Salgorkar College of Law, Miramar, Anjim, Goa. Over to you now. Next, Rani, please get ready. Varsha, please, over to you.
Thank you, ma'am. So we are going to present on the topic fragmentation and synergy, exploring the intersections of intellectual property and environmental law. So to define the intellectual property rights, those are the rights that are granted to the people over their creative work. So there are a set amount of times that they get or they are granted that is granted to the creators as the sole right to use his or her creations. So by empowering consumers to make knowledgeable decisions about the range of products and services, the protection of this distinguishing signs seeks to both protect as well as foster the fair competition that is there. So concerning the consequences of human activity on the environment, This environmental law refers to the web of conventions, the customs, laws, rules, and regulations which are there in order to protect the environment. So we see more of environmental pollutions, climate change activities in the economy now, and which are this environmental pollution is the central concept of these laws, environmental laws, which are also known as the natural resource and environmental law, and they are there for the purpose of safeguarding not only the various plants and animal species which are there that makes up our large ecosystem, but also our present and future generation environmental to provide them these things. These environmental rules and regulations are essential. So IP laws are offering incentives to increase the development of the green technologies which are essential in tackling the challenges of energy security, then climate change, biodiversity preservations. Achieving sustainable development, maintaining human health, and safeguarding the environment. These all things depends on the intellectual property rights, particularly the patent and the trade secrets. So while environmental law and the intellectual property law has long shared interest in the machinery, chemical, and the effects, that interest is currently growing more and more. Though the use of biotechnology such as the genetically modified organisms, new traits are being incorporated into living things. However, intellectual property protection stands in the way of the sustainable practices. In some way, in though there is a strong need to move away from the linear models of consumption, IP laws do not support most of the sustainable development objectives. So now coming to the fragmentation part, one area of potential overlap between these two legal fields is that the potential conflict between the exclusivity afforded by the intellectual property rights and the necessity of the widely disseminated environmental friendly technology. Moreover, what research indicates is that the curriculum of IP law education does not yet fully incorporate the role of IP rights in sustainable transition, pointing to a knowledge gap regarding how intellectual property interacts with the environment law. Now there are some ramifications of this thing. So while environmental law seeks to safeguard ecosystem and natural resources, intellectual property rights frequently place a higher priority on the innovations because this is important for the economic expansions. And thus the conflicts arise from the conflict between the environmental conservation and the profit maximizations. Second is the strict IPR enforcement may impede the spread of the environmental friendly technologies because for some of the nations which are still developing and they cannot adopt to this kind of environmental friendly technologies which are costing very high. So environmental friendly technologies with the higher cost such countries cannot adopt. So there can be also a problem here. Then a small number of conglomerates with the year's turnover greater than the gross national product of several developing nations have come to control over a disproportionate amount of high value IPR protected technologies and product. So then to the next thing, there is also a question about the biopiracy and cultural appropriation. Indigenous knowledge pertaining to the biodiversity and traditional environmental practices can be exploited to the IPRs without appropriate consent or the benefit sharing agreement. And lastly, there can be a divergence in the legal standards and jurisdictions arising from the fragmentations because there are a lot of bilateral and the regional treaties that are there, but I think there should be one treaty that is focusing on the entire globe. That's what I feel. So now I request my co-author to take forward.
And kindly note your co-author is having only 5 minutes left. Thank you.
Yes, ma'am. Now, today we'll be discussing about the synergy between the IP and the international law, wherein I will be discussing about the some few illustrations as in how the invention has been used as to address some of the environmental issues. For example, now there's something called as the BT cotton, that is the genetically modified, and this has helped the farmers as to reduce the use of the pesticides, which has also increased the annual productions from 3 millions to the 5.1 million tons. Then secondly, one such is we all know that the crops suffer from the increased soil salinity, and to address this, the Chinese scientist has come up with an named Yuan Longping has come up with an breed called as a seawater rice, which which is capable that the people are now able to cultivate even in the salty water. Then second is that third is about the agricultural drones like the DJI Agras T20, which is suitable for applying the fertilizers. Then DJI Mavic Mini, an easy to use drone for taking pictures. Coming to trademark, we have certain certification marks like the eco labels, wherein to name a few, there is a BAP, that is the best aquacultural practices. This particular symbol informs the customers that the fish comes from the accredited aquacultural facilities, and it not only protects the right of the workers as well as the biodiversity within an environment. Earth Check is one such benchmarking certification for travel and the tourism. Then to say that there are certain trademarks as to safeguard the information that is being used by the inventors. So coming to the conclusion part, what I want to say is that somewhere the need for IP synergy is needed as to protect the environmental issues. At the same time, the policies has to be such wherein the rights of the indigenous communities need to be protected. Thank you, ma'am.
Thank you so much, both of you who have presented very systematically on the given topic. Now I call upon Ms. Rani to have a presentation. Ms. Rani Sangamitra will be presenting the topic titled Synergizing Geographical Indication with Rural Development and Biodiversity Conservation. She is from School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. Over to you now.
Yes, ma'am. Am I audible, ma'am?
Yes, ma'am, you are audible. Before Rani can start up, I would like to request all the participants whose name is being called and who were not present on time to please message in the chat box so that we can allot you the slots. It is a humble request to put your names in the chat box so that we will give you time for presentation. Thank you so much. Over to you now. Rani can start.
Yes,
your
ma'am.
time starts now.
Yes, ma'am. My presentation deals with challenges in GI, impact of GI on biodiversity and rural development, and the policy frameworks such as TRIPS, WIPO, and GI Act in 1999 of India, and GI tax in India. So in general, Juchi mushroom from Jammu and Kashmir has got GI tag recently. As of now, on July 27, 2022, 420 registered GI applications were in India. 21 European GIs prioritize rural development over anything. According to the Government of India data, 167 products entered the GI markets between 2023 to 2024. GI products in India are now of 643. So what are the changes with regard to the geographical indication are the complex registration process. So the pending application in the GI registry are high. Several hurdles are faced by the people when getting to register the GI by the rural producers. The investment is also a big hurdle for them, and the procedure for registering the geographical indications is also a difficult one. Coming into the international geographical indications, it is very expensive to register them. Several states claim that GI for the basmati rice in India, but the US basmati rice is different from that of that in India. There is a need for strong law to prevent the misuse and unfair competition prevailing in the GI markets. There is a need for international collaboration in GI. Usually the developing countries are not giving significant recognition for the geographical indications, but the developed countries like Italy, Spain, and France dominate the field of IPR. Taking for example the Moga silk, which is in Assam, it is declining due to the climatic change. What happens there is, due to the climate change, there is a decline in the silkworms in Assam. It is affecting the production of the Moga silk there. So they are vulnerable. Not only the Moga silk is vulnerable, but also the Kanyakumari Bati bananas and also the Kashmiri saffron are vulnerable to the climate change. It affects the rural population. Geographical indications and biodiversity deals mostly with the agricultural products. All the products are registered under the geographical indication, but the agricultural products are important among them. It is connected to the natural resources, so it should fulfill the biodiversity objective when it is getting registered for the geographical indications. In order to protect the farming lands, sustainable farming practices should be adopted. GI can both help and hurt the biodiversity. It has both advantages and disadvantages. When a product is getting a GI label, there may be an increase in production, which harms the environment. So there should be a control in production. So the geographical indications cannot effectively protect the biodiversity and tradition at the same time. There will be loss of one thing at the cost of another. So geographical and indications and rural development deals with, there is increase in regional employment, and it prevents migration of people from rural areas to urban areas due to the lack of employment. It encourages agricultural tourism. If there is a geographical indicated product, it makes the tourists to come and visit those products and get it at the higher cost. So there is a higher pricing, but there is customer satisfaction and security. Then it gives a significance for the region. For example, the Nagpur orange, in order to buy it, the people may visit Nagpur, which increases its tourism. It also encourages the financial significance of the period of the place of origin. It encourages the people's talent, and also the traditions are preserved at the same time. The TRIPS agreement came into force in 1995, but prior to that, in 1800s itself, the France made special names for its wines. It is significant that there was GI before the enforcement of the TRIPS agreement. In 2006, European Union's preamble made an emphasis on the geographical indications, and the youth are vulnerable in the rural areas if there is no employment. GI provides for employment in rural areas. The French Comté cheese provides employment, though it is due to the pasteurization, a lot of lands are being deployed. It provides employment to the people. The African Union GI increases the African exports worldwide. In North Albania, the GI products are two. They are chestnut and chestnut honey. GI is boosting the rural development and the preservation of the environment. There should be a sustainable development, that is the economic development should be there, economic benefits should be there. The GI increases the income of the economy of the nation. Then there are producer benefits and consumer benefits. Both are benefiting, and the social, cultural, and environmental benefits are also there. GI mainly protects the environment. The policy frameworks related to GI are TRIPS. So the TRIPS as trade-related intellectual property rights. It is mandatory.
You have only 1 minute now.
Yes, ma'am. It is a mandatory for the World Trade Organization members, and the WPO recognizes the Lisbon Agreement, and the Geographical Indications India Act and made the provisions like Section 11, which is for documentation, and Section 32 for monitoring. And the government of India has made one district, one product, and the French fries and Rasagulla were once GIs. An inability to control the production made them as generic products. GI, when it becomes generic, loses its economic value. I'm concluding with the suggestions. So we should invest in the climate resistant crops in order to improve the GI so that they will sustain in the climatic changes. We should collaborate with the international, there should be international collaboration so that the other countries facing the same climatic changes shall share their ideas. Raised among the people about the climatic change and their impact on the biodiversity preservation. Monitoring and evaluation framework should be implemented for the to evaluate the impact of GI on the biodiversity conservation and rural development. I would like to thank Institute of Legal and Policy Research for giving me this wonderful opportunity to present my topic here. Thank you.
Thank you so much. Thank you so much. I hope all have presented here. I can see the fuel haq whose name